Welcome to This Week in Education Law, where I share up-to-date court decisions from the perspectives of educational administrators and policymakers. This is episode 41. In this episode, I'll introduce a recent case about educational administrators' retaliation after a school nurse advocated for students with disabilities. Let's first look at the background of the case. Amy Ray has been working as a school nurse since 2005 at Kennedy Middle School in the Woburn Public School District, Massachusetts. The alleged retaliation started in October 2011 when Ray began advocating for a diabetes policy to be implemented in the school. She claimed that the school principal, Carl Nelson, who allegedly had a disdain for students with disabilities, started intimidating her and insisting that students with disabilities should not receive special accommodations. The situation escalated over the years with different parties involved. In 2011 to 2012, Ray's nurse leader supervisor allegedly joined Principal Nelson in mocking her for rocking the boat by requesting more resources for students with disabilities. Ray's supervisor reportedly scolded Ray for asking for more funding to support the unusually large number of students with diabetes. Additionally, Ray's supervisor informed Principal Nelson about a minor Scribner's error in Ray's report, which Ray believed was used as a pretext for Principal Nelson to unfairly discipline her. By 2012, Ray reached out to Superintendent Mark Donovan and her union for help, but she claimed that promised resolutions were not fulfilled. In May 2012, Ray's union reached an agreement with the school district to put an end to the bullying and avoid litigation, but the superintendent reportedly did not execute the agreement. By August 2012, Ray had hired an attorney, but the superintendent allegedly avoided meeting with the attorney and made unfulfilled promises. In 2016, Ray wrote to the new superintendent, Matthew Crowley, about the district's failure to implement a diabetes protocol. Shortly after, she was denied a promotion for which she believed she was qualified. Specifically, on July 26, 2016, Ray emailed the new superintendent regarding the school's continued failure to implement a diabetes protocol. Just before sending this email, Ray had interviewed for a nurse lead promotion for which she was qualified and had seniority, but was later denied the position. Throughout this period, from 2011 to 2016, Ray alleged that Principal Nelson continued to harass her, including unwarranted disciplinary actions and public humiliation. For example, Principal Nelson allegedly thwarted Ray's attempts to assist students with diabetes, filed a child welfare complaint against a student's parents, leading them to verbally attack Ray, and made harmful jokes about Ray, insinuating she was excessively vigilant about students' safety. In November 2019, Ray filed a formal complaint with the school district's HR department. She claimed the subsequent investigation was biased and inadequate. According to Ray, instead of hiring an independent investigator, the HR department appointed the school district's legal counsel to investigate her complaint. Ray alleged that the superintendent tailored the investigation in the school district's favor and that she was not allowed to testify or present witnesses. The situation continued to deteriorate, with Ray filing a complaint with the Massachusetts Commission Against Discrimination in April 2012. In this complaint, Ray named Superintendent Crowley and Principal Nelson as the persons responsible for the retaliation she experienced. Even after filing the discrimination complaint, Ray alleged that retaliatory actions continued, including unnecessary disciplinary hearings, and public embarrassment. For example, on May 11, 2012, just 1 month after filing the discrimination complaint, Principal Nelson allegedly summoned Ray to a disciplinary hearing regarding a T-shirt containing a reference to alcohol that a student had taken from a donation pile without Ray's knowledge. In September 2022, Principal Nelson reportedly paged Ray repeatedly over the public announcement system while she was briefly out of the building using her inhaler. This incident led to another disciplinary hearing. This complex chain of events stretched over a decade and involved multiple levels of school administration, ranging from school principals to 2 school district superintendents, as well as union representatives and the school's HR department. It encapsulated numerous instances of alleged retaliatory actions, complaints, and grievances centered around Ray's advocacy for students with disabilities and her personal experience of workplace harassment. The United States Court of Appeals for the First Circuit ruled in favor of the school district because Ray failed to establish sufficient evidence to support her claim of retaliatory harassment under the Americans with Disabilities Act, Section 504 of the Rehabilitation Act, and Massachusetts anti-discrimination laws. The first consideration is the statute of limitation. Many of the allegations were deemed too old to be actionable. The court applied a 3-year statute of limitation for federal claims and a 300-day limit for state claims. This meant that much of alleged mistreatment from 2011 to 2019 could not be considered. If you were Ray, what would you do differently? To better protect your rights within the time constraints, you can take several proactive steps. You should file formal complaints about each incident of alleged harassment or retaliation as soon as it occurred. This would have created a timely official record and started the clock on the statute of limitations for each event. You should keep a detailed, dated log of all incidents, conversations, and actions related to your concerns. This ongoing documentation could have helped you identify patterns and provide timely evidence within the statute of limitations. You should schedule regular meetings with HR to discuss your ongoing concerns. This creates a paper trail of your attempts to address the issues internally. If part of a union, you can involve the union representatives earlier and more consistently. This can potentially lead to quicker resolutions or formal grievances that would have been within the statute of limitations. For the incidents that did fall within the time limit, the court found that Ray failed to plausibly allege a harassment that was severe and pervasive enough to create a hostile work environment. What evidence is deemed sufficient of severe and pervasive harassment? In this case, the court emphasized that for harassment to be considered severe and pervasive, it typically requires more than just isolated incidents, unless those incidents are extremely serious. The court focused on 2 key events that took place within the actionable period. First, in May 2022, Ray was summoned to a disciplinary hearing after a student obtained a T-shirt from the donation pile in her office. The T-shirt contained a reference to alcohol, something Ray claimed she was not aware of. The student had taken the T-shirt without her direct involvement, and it was not her intention to provide inappropriate clothing. Although Ray was not formally reprimanded, the disciplinary hearing added stress to her situation and was one of the key incidents examined by the court in evaluating the harassment claim. The second incident took place in September 2022. Ray briefly stepped outside of the school building to use her inhaler for a medical condition. She left a note indicating her return. During this time, Principal Nelson paged her 7 times over the school's PA system, despite the absence of a medical emergency in the school building. Ray was unaware of the pages because she was locked outside of the building. When she returned, she was immediately summoned to another disciplinary hearing. This event, perceived by Ray as public humiliation and unnecessary escalation, further contributed to her claims of harassment. The court found that those incidents were not enough to meet the legal standards of severe and pervasive harassment. Let's break down what this means and what evidence would typically be required to meet that standard. First, frequency is a key factor. Harassment is more likely to be considered pervasive if it happens frequently over a short period of time. For example, if Ray had been called into disciplinary meetings multiple times a day or paged unnecessarily several times a day for weeks, this could show pervasiveness. Next, the severity of the incident matters. A single extremely serious event could be enough, but it must be more severe than what Ray experienced. Imagine if the school principal had publicly accused her of professional misconduct in front of students and parents, resulting in immediate suspension without pay, that could be severe enough. Harassment involving physical threats or public humiliation can strengthen a case. For example, if Principal Nelson had physically blocked Ray from entering her office or publicly mocked her medical condition over the school's PA system, those behaviors of the principal could be seen as physically threatening or humiliating. There also needs to be proof that the harassment interfered with Ray's work performance. If she could show that the stress led her to make mistakes in administering medication, or that frequent interruptions kept her from completing important health screenings, this would demonstrate interference. The court also looks at whether the conditions of employment were fundamentally changed. If Ray had been relocated to a storage closet instead of her nurse's office or excluded from all staff meetings on student health, those changes would likely be seen as changing her employment conditions. Subjective feelings of distress alone are not enough. The court did not find Ray's experiences objectively severe from a reasonable person's standpoint. However, if other staff members had supported her claims, or if an independent investigator had deemed the incidents serious, it might have provided the necessary objective perspective. Finally, connecting recent events to a broader pattern of harassment could strengthen the case. If Ray had shown that she consistently received lower performance evaluations compared to her peers or was repeatedly denied professional development opportunities, this could establish an ongoing pattern of mistreatment. In essence, the court was looking for evidence for more frequent incidents, more severe consequences, or a clearer demonstration of how those events significantly impacted Ray's work environment. This is a high bar set for proving a hostile work environment claim. It is important to thoroughly document and report all potentially harassing incidents as they occur. What can school administrators learn from this case? In this case, the school district won the case not because school administrators did the right thing, but because of insufficient evidence that proves severe or pervasive harassment. This outcome should not be seen as a validation of the school district's behaviors, but rather as a cautionary tale for both employees and administrators. The decade-long conflict between Ray and the school administrators suggests a failure to address underlying issues effectively. While Ray first raised concerns about the diabetes policy in 2011, administrators could have scheduled a meeting with Ray to fully understand her concerns, formed a committee to review and potentially update the policy, and provide Ray with a clear timeline for addressing the issue. If Principal Nelson had said, "I appreciate you bringing this to our attention. Let's set up a meeting next week with the special education team to review our current practices and policies," this response could have a collaborative tone from the very start. The repeated disciplinary actions against Ray raised questions about whether policies were being applied consistently and fairly. Ensure that you have clear written disciplinary procedures, make the disciplinary process more transparent to all staff, provide clear explanations for disciplinary decisions, and offer an appeal process for employees who feel unfairly treated. Remember, while the school district prevailed in this case due to legal technicalities, it is not a model for best practices. Our goal as educational leaders should be to create a supportive environment for all staff and students, not a toxic work environment.